All right. With that, we will invite the petitioner to come up and provide their closing remarks.
It'll be Amaroq Weiss.
President Sutton, members of the Commission, Director Bonham. My name is Amaroq Weiss. I'm the West Coast Wolf Organizer for the Center for Biological Diversity. We thank you for this opportunity to present petitioners' perspective on the law, policy, facts, and precedent regarding listing the gray wolf in California. Gray wolves are endangered in California. Everything we know points to listing. Gray wolf is known to be present in California. Every year now, for 4 years in a row, this wolf has made California part of its range. And in fact, Dr. Loft just noted to you that the department views OR7 as an intermittent resident of California. The legislature has provided the listing and delisting standard. A species is endangered if it is in serious danger of becoming extinct throughout all or a significant portion of its range. We note that listing a species and taking a species off the list, they both utilize the same standard. Species on the list are to be reviewed every 5 years, and if the state thinks that they no longer qualify, the state can remove them from the list. The legislature did not grant the Commission discretion to substitute special management standards in lieu of listing. The statute is the standard. Neither the agency nor the Commission can make up new rules to prevent a species from being listed. Range means California range only. This has been interpreted by the courts. A species' presence outside of the state is of no consideration when it comes to listing, but a species that makes California part of its range definitely falls within CISA. The range of the gray wolf clearly includes parts of California historically and at present. And again, I'll refer to Dr. Loft's remarks a moment ago, in which he indicated that the department would stipulate to the fact that wolves once ranged widely across the state. There is no continuous presence standard for listing a species. In order to find that a species' continued existence in the state is facing threats and is in danger, there is no requirement that the species have a continuous presence in the state. There also is no breeding population standard. The Guadalupe fur seal at one time was thought to be extinct until a breeding population was discovered on Guadalupe Island in Mexico, and the listing in California occurred only after a few sporadic sightings of a few individuals in the 2 years prior to listing. Dr. Loft earlier noted, again, that OR7, like the Guadalupe fur seal, has been an intermittent resident of California. Director Bonham's memo that accompanied the department's status review and the recommendation specifically notes that because there's no breeding population of wolves at this time and because there has not been a continuous presence of wolves, the department could not do a typical evaluation under CISA. I'd like to bring to the Commission's attention, and I provided you with copies today, on April 3rd, we submitted a Public Records Act request. We want to thank the department for responding so quickly. As of yesterday, we had already received approximately 5,000 documents of comments that have come in from the public since the February 5th hearing. Among those documents was a letter that was recently sent by one of the scientists' peer reviews to the department, which is an update to her peer review report. I was not sure whether or not the Commission had seen her update letter, which came in late March. Dr. Christina Eisenberg, one of the nation's leading wolf ecologists, has written that it is her scientific opinion that the gray wolf should be listed under CISA. And the basis for her opinions are that OR7 has continued to visit the state in California again this year repeatedly. California has a precedent of extending CISA protections to species that have no known population occurring within the state, a fact she did not know at the time she conducted her initial peer review. And that based on current science, she finds that overexploitation could jeopardize the species in California. Under the statutory listing delisting standard, listed species absent from the state were not delisted. The Guadalupe fur seal was not delisted during times it has been absent from the state. The California condor was not delisted during the 5 years it was scientifically known that there were no animals, no condors in the wild. The wolverine, there was no confirmed wolverine for 50 years at the time it was listed, and it was another 40 years before another wolverine was seen, and yet in all that time, the state did not delist the wolverine. This has been and remains true, despite any suggestion that the standard has changed over time. Each of these species benefit from CISA listing. This is consistent with the statute's objectives of conservation, protection, restoration, and enhancement of listed species. The gray wolf would also benefit. This is common sense. Of course these species should stay on the list. So, of course, should the wolf be on the list, and it should stay on the list. If the fur seal all swam to Mexico next year, they're not coming off the list. We know they come back. The only species removed from the CISA list were either recovered or went extinct. There's no example of a species with facts similar to the wolf that was denied listing or delisted, not from intermittent presence, not from complete absence, nor for lack of breeding. For the fur seal, the condor, the wolverine, and the wolf, their continued existence is in serious danger or is threatened by one or more of the 6 factors in Section 670.1. The fur seal, condor, and wolverine were all completely absent from the state for up to decades in some cases, yet they were listed. Though they've not been continuously present, they have not been delisted. Why? Because there is a danger to their continued existence in the state. This is what the Commission has always done. This is what the legislature clearly wanted. This is how the courts have interpreted the act. We don't know for certain whether gray wolves have yet established a continuous presence in California, because we only know about the individuals that are collared. But we do know their continued existence in California is in danger, as was just pointed out with a good legal argument by President Sutton. Of the 6 factors of Section 670.1, any one of them is sufficient to find that listing is warranted. The Department has acknowledged that there do exist threats to wolves in California from overexploitation or by natural or human-caused activities. And while the Department's report indicates that such threats are only potential, not actual threats, the Department's actions say otherwise. In 2012 and in 2013, the Department was sufficiently concerned for OR7's life and for the life of any other wolves that might be entering that northern pathway, while the coyote drive contest hunts were taking place in Northern California. They were afraid that he could be mistaken for a coyote and shot or intentionally killed during the contest. And they were so concerned that they sent staff to the northern counties in both of those years, even before the conservation groups knew about it and brought it to the Commission's attention. They sent staff to that area to advise contest participants that the wolf is federally listed, that it's illegal to kill a wolf, and to advise them of the difference in appearance between wolves and coyotes so that they would not make that fatal mistake. And just last week, during a wolf plan stakeholders meeting, Department representatives stated that on one occasion that OR7's radio collar signal indicated that he was moving through an open area near the river south of Redding, their instantaneous thought was fear for his safety because they were concerned that someone would mistake him for a coyote and shoot him. These threats to OR7 or to other wolves that could be in the state now or that may be entering the state, they're more than potential. They have been enough of a threat that the Department has felt the need to intervene. Listing remains or is warranted for each of these 4 species, even though each has or does periodically leave the state. There is nothing legally unique about the petition to list the gray wolf, as I've stated. To reiterate, the legislature did not grant the Commission discretion to substitute special management standards in lieu of listing. It's odd that the agency thinks that the wolf does not warrant CISA protection, but thinks it is imperative that rules should be adopted to protect wolves from being killed by humans. No amount of such alternative protections changes the standard by which the Commission must list. Gray wolves are returning. Their listing is inevitable. The Department, the Commission, the public, and the wolves all benefit from listing now rather than later. What matters in the final analysis is that the Commission's and the Department's interpretation of CISA furthers the legislature's intent in enacting the state's Endangered Species Act of protecting native species and their habitat for the value of Californians. We all know what CISA is for, and we all know the wolf deserves listing. No matter how worked up that's going to make a tiny vocal minority. California is a leader in acknowledging the best available science when it comes to wildlife, and the current science is informing us of the essential role of apex predators in the web of life, and that apex predators the world over are in sharp decline due to overexploitation and other human activities. Science tells us that the healthy planet that we all depend on depends on the continued existence of these apex predators, and that measures to conserve and recover them are urgently needed. Everything we know points to listing. The science, the policy, the legal listing standards, and past precedent. We emphatically urge the Commission to act accordingly. Thank you.
Thank you. Thank you.